calling the meeting to order at approximately 8:35. Do we have any veterans in the house? We have two. I'd like the two veterans, we did two veterans to lead us in the Pledge of Allegiance, please. Can you come? Yes. Pledge of allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Thanks to the veterans for serving our country. I'd also like to indicate that a proper notice has been given as required under the Ohio Revised Code 121.22. We're going to follow the agenda because we have a very busy agenda, so I'll try and stay on target with that. Our board meeting minutes from August the 10th and August the 16th of 2021 were sent out to the members. Everyone should have had an opportunity to review those. Any questions about those minutes as you received? If not, I'd like to entertain a motion to approve.
I'll move that we approve the board meeting minutes from both the August 10th and the August 16th, 2021 Board of Elections meetings.
Second.
All those in favor?
Aye.
Aye.
Anyone abstaining? Anyone opposing? That motion carries. Next, agenda number 5, certification of the November 2021 general election nonpartisan candidate petitions with filing deadlines after August the 4th, 2021. Ms. Pollock, can you give us a discussion on this, open us up so we can get started?
Sure. In your packet, you have a 2-page document that's entitled Hamilton County Nonpartisan Candidates List with Filing Deadline through August 19th. This includes candidates for City of Cincinnati, Member of Council at Large, City of Madeira, Member of Council, City of Springdale, Member of Council, and Village of Amberley. All those jurisdictions had filing deadlines after the last time you met. Staff has reviewed the petitions listed on this document and found them to be sufficient and recommends certification.
Okay.
All right, on this list, Madam Chair, I'll move approval of these candidates listed on this 2-page report. I'll move that they be certified to the November 2nd, 2021 general election ballot.
Second.
Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you.
You have another, a document in your packet entitled Board Review. Staff reviewed the petitions of the candidates on this list and have found them to either be insufficient or to need board review. And we've broken them down into similarly situated circumstances. The very first category, staff has found these petitions to have insufficient signatures. This is for the City of Cincinnati, and there are 6 candidates listed in this category.
Madam Chair, I know at this juncture, I know council is here on at least 2 of the candidates listed in this report. That would be Mr. Hartman, who I know has communicated some with board staff. I don't know if there's counsel here for anyone else. I just know that because I frankly asked counsel as I walked in whether he was representing both, and he indicated he was. And I see at least one of the, both of the, Mr. Brinkman and Ms. Matthews, I know are here, who are listed on this report. Again, there may be others here as well that I just personally don't recognize, but just wanted to know what the board's thoughts were about process here, so everyone feels like they certainly had a fair opportunity to address the board before we start making decisions.
Well,
or maybe I'll look to our counsel to give us guidance as well.
I think that we should allow individuals to come up and speak on their behalf to get us started, those who are representing individuals as well as those candidates who are here and would like to say a word, not more. So let's start first. Doesn't matter. Let's start first with the City of Cincinnati. I'd like to start with just a moment. Members of the Council at Large.
Madam Chair.
Insufficient signatures. Let's start with that first. Yes.
Madam Chair, but before we begin this, I would like
just advice from council as to our specific obligations right now. Are we conducting a hearing? What is this process? What is the process going forward? And what are the rights of the candidates who may or may not make the ballot? So if you would indulge me for a second, Mr. Stevenson.
Yeah, the bottom line on this is if these people intend to produce evidence prior to your decision, that's not allowed. You cannot add to a petition once it's been filed with the board. I know that in the past there have been situations where things have happened like that, but the bottom line is that state law prohibits you from considering additional evidence with respect to a petition prior to a decision being made. Candidates are free to file for reconsideration if they are not put on the ballot. And the board, if it chooses, it's not required to, but if it chooses to reconsider its decision with respect to particular candidates, they must look at the evidence that they choose to present. Typically, that would happen at a later date.
Okay.
We went through this with the mayoral process back in May, where we had candidates coming in and essentially speaking off the cuff about the petitions that had been filed. And at that point in time, we asked them to file something in writing.
Right.
And then we had a hearing at a later date. If you have any additional questions, Chip, I'd be happy to.
Just to clarify for everybody here, so from a procedural standpoint, the opportunity to provide specific evidence regarding signatures, part petitions, whatever the issue might be, occurs if they've been deemed to have an insignificant number of signatures, and I'm referring to the first six
Sure.
on this page, insufficient number of signatures.
Sure.
They're then rejected from the ballot by this board. Then their due process rights, they have the opportunity to petition. It's up to us to accept that and listen to evidence. And if they provide evidence, then we have to listen to that evidence.
It's the board's choice whether they
Right.
choose to accept evidence. But if you do have a reconsideration hearing and there is evidence presented, you must look at that evidence and you must make your decision based on that evidence.
Based on that evidence. Okay. Thank you, Mr. Stevenson. Thank you, Madam
Gotcha.
Chair.
Thank you. So should we do public comment first?
No, I think
Let's do it. Gary, let's do the insufficient signatures first. So who's going to explain and clarify what those insufficient signatures were? Can you do that, or do we have someone that's coming in here to do that?
Well, on the 6 candidates listed under that category, staff reviewed their part petitions following the guidelines in the Secretary of State Election Officials Manual and found those candidate petitions to not contain the number of required valid signatures.
And those candidates have been notified?
Yes,
Am I correct?
yes.
Okay.
That's my belief, that staff has notified those candidates by phone.
Okay. So let's start with public comment, or you want to say?
No, that's fine. Like I said, one gentleman here threw up his hand as well. I know Mr. Hartman is moving about and signaling that he wants to be heard. I think it's fair that, I know Mr. Stevenson's
So
advice is, but I think I'm with you, Madam Chair, in terms of hearing from folks at
Right.
this juncture, even on what Mr. Stevenson is suggesting to the board, and that is that we can't accept new evidence. I
Right.
suppose ultimately we can decide what you present, so whether it constitutes new evidence. But I certainly wish people who are here should have a chance to be heard.
I agree.
Yeah.
And so do we have just one legal person representing anyone, which is Mr. Hartman, or regarding insufficient signatures, or is there someone else in the House?
I see Mr. DeMarco as a counsel too, but probably just on the question of the ballot initiative, right? Yeah. And then, sir, you are, I just see you raised your hand a couple times. Second.
Can we just start with, what?
Got a question.
The city
for
solicitor?
Your name, sir?
Madam Chair, my name is Rob Harris, candidate for Cincinnati City Council.
Thank you, sir. All right.
Am I quit, Madam Chair?
Yes,
Is it okay if I raise this question?
yes.
It's mainly legal counsel. He stated some one clarification. When the candidates received the call, it was just, my understanding is you can come before the board. There was no explanation that evidence needed to be provided right then and there. At this point, evidence needed to be provided prior to the board. But yet I hear that the board can also make a decision overall. That's pretty much what I'm hearing from you. So I just wanted a clarification at that point in time.
I think you have maybe a misunderstanding, maybe you don't, but the bottom line is that the board will be making a decision based on these candidates. And I notice, Mr. Harris, you're in a separate category other than the number of signatures. But what the board is going to be making a decision on is whether or not to accept a staff recommendation on these candidates. If you have something particular that you want to say, obviously you're going to be in a separate category. You're down a couple more. But the bottom line is that what they cannot do is accept additional evidence that relates to the petitions at
That's
this
right.
point in time.
That's right.
If there are issues with the number of signatures that the board has determined to be insufficient, if a candidate chooses to file for reconsideration, and I'll say again, the board is not required to hear a reconsideration petition. They're allowed to. If they do hear a reconsideration petition, they have to look at the evidence at that time that would be presented. Okay? Does that clear everything up for you or not? Okay.
So as I understand it then, just hypothetically, and I have no idea, Mr. Harris, where we are on yours, I'm here to collect
He is
information.
down as a member of council at Lake.
Sure, but I mean, in terms of how we decide, but if we were to decide that you were rejected, you would still have an opportunity to petition for reconsideration.
Right.
And
That's
at that
correct.
point, we could listen to additional information. Does that clarify it? That's my understanding of it. I think that's.
Right, and what you're not required to do today is present all your evidence today.
Right.
Okay?
Okay, so we're going to take them numerically, and there is also, the city of Cincinnati has legal representation here as well. Yes, and what's your last name, please? Thank you. So I'm going to start first with at large, and we're going to do it as indicated. First is Darius Clay. Is there Darius Clay here? Seeing that he is not. James Jenkins. Okay, seems like he's not present. Linda Matthews.
For the record, Linda Matthews is present with counsel, Mr. Hartman.
Mr. Hartman, thank you.
Thank you. Thank you, Madam Chairman. On behalf of Ms. Matthews, it is going to be necessary on an issue. My understanding is the deficiency arises from a single-part petition that was rejected in whole because the total number of signatures indicated on the circulator statement was less than the number of signatures on the petition itself. I understand that that is the general default rule, but I also believe that was precedent from the Supreme Court does allow and provide for testimony presented to explain that deficiency, and that's what would be necessary in that case. I would disagree a little bit with Mr. Stevenson. I think the board can take evidence at this stage. It's not obligated to. It does take evidence. It does become a quasi-judicial proceeding, where we can jump through the hoops, deny a petition, then request the hearing or reconsideration. Recognizing the time crunch that the board always faces at this time of year, and potential of mandamus actions or prohibition action, depending upon what the board's, as I think the board should consider in terms of efficiency, official economy, to accept some evidence today, either before it makes the decision or after it makes the decision. Ms. Matthews is here, is ready to proceed to present about 1 or 2 minutes worth of evidence, and we can get the disposition. So, with respect to that, the issue with respect to Ms. Matthews is there's
I'm sorry to interrupt, Mr. Hart.
Yes.
Could you speak more directly to the microphone? What we're getting notes that you're not being picked up.
Okay. How?
Yeah.
Yeah, it's on. The basis is, and the basis would be a Ohio Supreme Court case that we would rely upon. It's State XRL Schwartz versus the Hamilton County Board of Elections. Citation is 173 Ohio State 321. It's from 1962. Factual scenario is a person, and at that time it was an affidavit, a circulator statement. The petition contained 28 names. The affidavit indicated the total number was 27. The person offered testimony before the board explaining that difference, and the Ohio Supreme Court said based upon that testimony, the board had the duty to accept the part petition and to place the individual's name ballot. I think the situation, the evidence will be comparable to that evidence, and I believe that would be the basis there. So again, how the board wishes to proceed in terms of evidence, Ms. Matthews does need to present about 1 or 2 minutes worth of testimony to establish the foundation for that. So I don't have a pure legal argument in terms of at this stage with respect to her petitions.
Mr. Stevenson, not to get too legal, but couldn't we just hear it by way of a proffer that we could or couldn't consider later since everyone's here?
I think you hear it after you've made your decision. The state law is very clear, a petition cannot be added to after it's been filed, and I think if you're considering evidence prior to making your decision, I think that's adding to the petition.
Would it be in order for an oral motion for reconsideration to be made here today after the board makes its decision?
That's up to the board.
I would support that only because everyone's here, right?
Well,
And
they're
what
all
Mr.
here,
And
so
the process that Mr. Stevenson has outlined for the board, obviously, we're going to follow his legal advice.
Absolutely.
But the fact of the
Oral
matter
would
is,
be
yeah,
fine.
I just, because people are here and because this board needs to get to the business of printing the final ballot and
And we're running
preparing
out
for
of
an election,
time.
right?
The deadline's coming. So, Mr. Hartman, have you concluded?
I've concluded with respect to Ms. Matthews. Like I said, I don't have the pure legal arguments at technical, so if the board wants to reject her, I'll come forth at the appropriate
Okay.
time, make that oral motion on her behalf.
Thank you. Thank you, Mr. Hartman. Ms. Matthews?
I have a quick question for staff.
Yes.
Like, what kind of timeline are we looking at as far as if we have a reconsideration for us to be able to make the ballots? Because I know UOCAVA ballots have to be ready, like, was it next Monday?
10 days, 10 days
Yeah.
from today, correct. Yes, so obviously to get these matters settled as soon as possible.
You'd probably have to hear it sometime this week, Joe.
Okay.
Okay, okay. Ms. Matthews, do you have any other questions?
No.
Ms. Matthews, could you step to the microphone, please?
I don't think she has anything really to add.
Morning, everyone.
Good morning.
Morning.
Just my testimony to the chair and to the board. On July the 23rd,
I'd
21.
swear in if you're going to do, if we're going to, yeah, I'm sorry, Ms. Matthews, if we're going to take testimony at this juncture, which again, Madam Chair, I think the idea here is that,
Have her swear.
well, I think Mr. Hartman said he would be making an oral motion for reconsideration to hear evidence consistent with the process outlined by our counsel. And Ms. Matthews, you'll certainly have a chance to offer this testimony. I think it's a question of when you do it.
Okay.
And I think at that point, you'll be asked to take an oath before you offer the testimony. So I think whatever you're going to do, I think just probably has to wait just a little while, just a few minutes maybe.
I think we need to do that.
Fair enough?
Yeah.
Yeah, okay.
I'm done.
So I think that's why Mr. Hartman would probably, as your counsel, prefer that you wait to provide testimony. Fair?
The only thing I heard Mr. Hartman saying was that she would give her testimony in less than 2 minutes, so that was the only reason I called her to come up. Okay, so thank you. Next is Robert Moore. Robert Moore, present.
Anybody representing Mr. Moore?
Victor Phillips. Anyone here to represent Mr. Phillips? And, oh, please don't let me mess his name up. Yes. Thank you, sir.
Are you him, sir?
Yes.
Yes, sir. Good morning.
Good morning.
So you just want me to present? I don't think this is new evidence at all because this is just, I guess, the Secretary of State website and just checking up on and see if the people were accurate on my particular petition is not really new evidence. So what I would say is, it's blatantly a lot of people where they said that the address didn't match the signature, and it did. A lot of them. I have this. I didn't even get to match these up. These are the ones I didn't even go through yet of my petition. I have roughly about 33. But I would say 25 definitely. 33 or something where you can, you can kind of get some leeway. But 25 of them definitely where it was said that, and I have them here. In fact, I have them stapled. Secretary of State website where it has their name and then it has their address, and I have it stapled to the actual petition. We can show that their name does match the address on the Secretary of State website, and when you print it out. So I have it here for you all to see. I have at least about 15 here. If anybody seen me walking in, I was trying to kind of get them together because I was told about this. I didn't know exactly what time it was. So, but I have about 15 here if anybody wants to see that when they said that the address did not match, it does. And on the Secretary of State website, I didn't have to come here and sit down. Even though I was here all day on Friday, I took off on Friday just to do that. But yeah, you can see this. It's blatant. I can hand it to you all. You can see where it says, it has the address, and the address does match when you print it out from the Secretary of State website. So this is I have 33, and like I said, I didn't even go through this pile to find more. Of me just and I don't want to use those different words, but I just want you to, if you wanted to have this, you can have it. You can see it.
Mr. Rizzo, you're fine.
Mike,
I have a question for you, if that's okay, sir. So you're just so we're all clear, you're asserting that some of the people who we rejected as having a bad address actually have a good address, and that the board staff is incorrect in that pronouncement.
A lot of them. In fact,
Okay.
I didn't even get to go through these.
Okay.
I was here all day and got these. Yeah, on Friday. I was here on Friday. Yeah, it was on Friday. I seen me all day over there. And I got these. And I only got 33 because, you used to kind of lot.
But
Can we have Ms. Poland, please? Can you comment, please, regarding his signatures?
I can tell you that after staff found 355 valid signatures on the petitions that were submitted, and 500 valid are required for Cincinnati City Council.
So insufficient signatures to meet the requirement of 500.
That's correct.
Okay.
And they
then-
said I had 380 without the address didn't match the signature. It said 380 of them. So all I really needed was a third of those, and I'm saying I definitely have them. In fact, I looked, and when I was going through the page, I said if I at least had four each page, I would have my goal. And I said some of them I got more than 4 each page, some of them I got 4 each page, where it was just wrong.
Sir, it appears to me that what Ms. Poland just shared with you is that you still have insufficient signatures, and that therefore does not meet the threshold of 500, which is.
I got out here. We got 900. It's 900 some signatures on. So I was, if I was to have 355, but now I have 437. I really want to know exactly how many I actually have instead of someone not doing their job. I mean, like I said, this. I mean, if you don't look at it, I want you all to look at it.
But from.
I'm happy here for you to.
But Ms. Poland has the same documents as you do. Bipartisan staff have reviewed everyone's signatures, and that you did not meet the threshold.
Well,
And so I
I have one right here. It says it has the A, has the address thing right here. Carlos Boyd. If you go by Carlos Boyd right here, you can see that is his address. I have another one.
He's asking to give testimony right here, so I think at this
Yeah,
point,
I-
at this juncture, it's
I have them
inappropriate.
right here for you all to
So what we're
look
going
at.
to need to do is have you come schedule a hearing.
Because I really want to have my actual
We're gonna,
number.
what you were able to do today was just give a brief public comment, but it appears that you are challenging the final vote numbers that were counted. So we would have to schedule you to come back for another meeting, for a protest.
No, they said
Thank you.
355. Okay, that's it. That's all.
Thank you, sir.
All right.
Thank you. Okay, so we've gone through the insufficient signatures. Next is the City of Cincinnati missing date of signing and circular statement regarding members at large council, at least 2-year term.
Madam
Yeah.
Chair, before we get to the next matter, I just want to ask Ms. Poland and Mr. Stevenson, we should deal with these in specific categories, correct?
I think so, yeah.
Okay.
We have 5 categories, so we've heard all we're going to hear at this point at
That's
least
correct.
regarding insufficient signatures. So should we take a vote on that now and then move to the next category?
Yeah.
I'm comfortable with that, yes. So if we do them individually.
You
that
should be
means-
doing the candidates individually. So you start with Darius Clay and move all the way through.
Okay.
And, excuse me, Madam Chair,
I'm,
does that require that's a motion made by a board member specific to each individual, correct?
Yes.
Thank you.
okay, so if we start with Darius Clay, and as you recall, some of those individuals are not here, but let's start with Darius Clay first. Need a motion.
Madam Chair, I move that we reject Darius Clay from the ballot due to insufficient signatures.
Second.
Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. The next person is James Jenkins.
Madam Chair, I move that we reject James Jenkins from the ballot due to insufficient signatures.
Second.
Any more discussion? All those in favor? Aye.
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 Anyone opposed? Anyone abstaining? That motion carries. Next is Linda Matthews.
Madam Chair, I move that we reject Linda Matthews from the ballot due to insufficient signatures.
Second.
Any more discussion? All those in favor? Aye.
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 Anyone opposed? Anyone abstaining? That motion carries. Robert Moore.
Madam Chair, I move that we reject Robert Moore from the ballot due to insufficient signatures.
Any more discussion?
Second.
Need a second? Okay, we got a second. Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Next is Victor Phillips.
Madam Chair, I move that we reject Victor Phillips from the ballot due to insufficient signatures.
Second.
Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Next is Nathaniel Israel.
Madam Chair, I move that we reject Nathaniah Israel from the ballot due to insufficient signatures.
Second.
Any more discussion? All those in favor?
Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you. So the next area is missing date of signing in circulator statement. Do we have anyone in the audience that wants to comment? There's representation. Mr. Hartman?
Mr. Brinkman's name on the website.
It is.
Yes, yes.
Yes, I would have an evidentiary matter to address afterwards, but I think there is a legal issue that this board has to consider. I believe that the omission of the date on the circulator statement, not on a signature on the petition, but on the circulator statement, is not a vital or material provision of the petition. The Cincinnati City Charter, in defining the petition form, only requires substantial compliance. Consider it, if you look at it, because I think that date's kind of a holdover from the affidavit that the city of Cincinnati has now said is basically no longer needed on these circulator statements. The attestation of the circulator statement is clearly made under penalty of election falsification. The date of that signing is not material to that. You look at the standard form petitions that are issued by the Ohio Secretary of State. Those circulator statements are made under penalty of election falsification. No date is required. So therefore, any penalty or the threat of penalty is not contingent upon the date of signing. So in that sense, the date on the petitions are immaterial, are not vital. I would call the attention to the board. There's a case out of, I believe, Warren County, State XREL, Eshelman versus Fornshell, 125 Ohio State 3rd 1. In that case, it wasn't an issue of a date of a circulator, but it was actually the date of the election in the declaration of candidacy was left blank. And the Ohio Supreme Court found that wasn't deficient to the petition and therefore ordered the person on the ballot. So as a legal principle, the inclusion of a date is not material in the current form of the petition. Secondly, it does substantially comply with the requirements of the petition in the city charter. For that reason, I would ask the board to accept the part petitions that were rejected due to no date, and in that sense, Mr. Brinkman would then have sufficient number of signatures.
Thank
Any
you.
questions from the board?
Not at this point. I'd like to hear next from the city of Cincinnati. Ms. Warner, please.
I would object to the city providing statement unless Ms. Warner can establish on whose authority the city solicitor is weighing in here. Under Article 3, Section 2 of the Administrative Code, the city solicitor shall be the legal advisor of the city government and all of its agencies, and shall represent the city as attorney and counsel in all proceedings in which the city is a party before any court or any governmental commission having judicial power. They are not a party to this portion, and an attorney is not a roving person to come out and start making statements on behalf of a client. They operate as an agent of a client. And so I think Ms. Warner, before she even addresses this board, needs to establish who authorized her to be here today. Was it the mayor, the city manager, a council member? We know city council did not authorize her to be here. I believe both in terms of procedurally and ethically, she needs to establish who actually authorized the city to weigh in at this stage.
Thank you. Ms. Warner, please.
Before we go on with that, just for Mr. Hartman's information, we asked the city solicitor to comment on the charter
Yes,
provisions.
that's what I was going to say after she spoke, because we did raise the question, and by the date of the circulated signature signing, and is that required as an essential element of the City of Cincinnati Council candidate petitions?
Let me just respond. I would still object to her providing any statement or testimony. Inviting an attorney, the attorney still has to get permission or authority from the client. I don't know
I think
what client authorized the city to weigh in.
if you will allow her, please, to answer that question. Ms. Warner, please.
Good morning, members of the board. As Mr. Stevenson stated, the city solicitor's office did receive a letter from the Board of Elections asking us to provide our interpretation of the city charter. The letter didn't have a candidate listed in that, so we were offering just our legal interpretation of the charter. Of course, I am here as an attorney for the city of Cincinnati, and with the full authority of the city solicitor and the city manager, who is the chief executive in our form of government. And so there's no issue there. We did provide our interpretation of the charter's requirements to the board on Friday. And so briefly, that is, yes, that Article 9, Section 3 of the charter does provide the form of the petition, including the circulator statement. And that section does say that it is substantially in the form of what's listed. What's listed in Section 3 is that it includes a date. The other part of the charter that it is our opinion the board needs to consider is Section 2, which also deals with these petitions. And Section 2 says that the signatures shall include a date, among other things. So it is our opinion that when you read those two sections together, that the date is a requirement of the charter. And it's our opinion that absent, some other authority, which we have not found, that the words of the charter have their meaning, and so it is a requirement. What the board does with that, of course, is up to the board and its legal counsel. I can't opine as to the board's obligations. So if there's any questions, I'm happy to address them to the extent that I can, but I'm really here because the board requested our opinion, and we wanted to be available in case there were any questions.
So again, if you can, from what we received from the city, it's very clear that that the signatures, the address, and the date of the circulator signed on the form is significant. Also, that's with Section 3, and then with Section 2, it reiterates again that the circulator's name, address, and date of signing in ink is a requirement by the Cincinnati Charter.
Yes, Ms. McFarland. And I also wanted to add that it's our understanding that the board has used that date of the circulator signature in the past to verify the petition, the electors' signatures. So if a circulator said, as of August 1st, these were all of the signatures, but there were some elector signatures dated after August 1st that those would be invalidated.
That's
So
true.
it's not just superfluous, it seems like it does serve a function.
Thank you. Anyone have any questions?
I do, in fact. So I don't necessarily mean to jump ahead, but your opinion was on two topics where we asked for your opinion. It seems they're contradictory in the sense that the second portion of your letter, Ms. Warner, Mr. Garth's letter, but you're here representing the city, is suggesting that the very same requirement that you not have more than 1,000 be ignored by the board, and that we allow the person with more than 1,000 signatures access to the ballot, right? So just so we're clear, so the first portion of the letter suggests that Mr. Brinkman shouldn't be on the ballot. The second portion suggests that the person who got more than 1,000 signatures should be on the ballot. Is that a fair statement?
Respectfully, not quite, Mr. Triantafilou. The distinction that we thought was important is certainly the board, it is our opinion that the board may not consider any signatures over that 1,000 maximum. So that is a mandatory requirement. The question then is, what do you do with any signatures over that 1,000? And we thought that there is support for the board to simply disregard the signatures over the 1,000 instead of throwing out the entire, the entire batch. But again, that there is not support in the charter that mandates you throw out the entire petition set for having more than 1,000 signatures. To be clear, that restriction is that no more than 1,000 signatures can be considered. And again, I would defer to your counsel as to what that interpretation means for the board's obligations.
Okay. So just to follow up then to the chair's question, she used words that lawyers always find difficult, and that is she used the words very clear. It seems to me like the first part of your opinion suggested that the board should defer to its counsel, not that it's very clear. Did you agree with the words that it's very clear? Because it's certainly not very clear to me.
Mr. Chair, I don't know the clarity or not. I think our opinion is that the charter requires the circulator signature date to be included. The charter requires that the board consider no more than 1,000 signatures for the second part of your question. And then again, I think that's our interpretation of the charter. What the board does with that information, I would defer to your counsel to explain your responsibilities.
There's nothing else from Ms. Warner.
So-
Thank you for being here.
Thank you, but it also continues to say it must include dates and et cetera as well, as in section 2 and 3, in relationship to the 1,000 signatures.
It is from that same section, correct?
That's right. Okay, just point of clarification. Anyone have any questions?
Madam Chair.
Yes.
Ms. Warner, with respect to the 1,000 signatures, how would you advise us to, which 1,000 do we count? Where do we stop?
Mr. Gerhardt, I don't know that I can advise. I think the question, the two options that were posed in the letter, I think were to consider the first 1,000 or to throw out. I would defer. My belief is that the board staff has handled this in the past, and so there might be some past practice, but again, that's really outside the scope of what I'm here to answer.
Okay, so the city cannot, although it said count 1,000, it can't advise us as to which 1,000 to count and which to reject and where to start and, okay, thank you.
Thank you. Ms. Poland, Mr. Mallory.
Can I be heard rebuttal, because I think it was unclear. I've not seen the opinion. I want to address what Mr. Warner just
I think it's appropriate to give him a rebuttal.
Is that appropriate, Mr. Stevenson?
I'm looking at section 2 of Article, I think, 9 of the city charter.
Mm-hmm.
And I'm reading that, and midway during the first paragraph, it says, signatures to nominating petitions need not be appended to one paper, but to each separate paper there shall be attached an affidavit of the circulator thereof, stating that each signature thereof was made in the circulator's presence and is the genuine signature of the persons whose name it purports to be, period. Now, of course, the city, in a show of hypocrisy, is saying, forget the affidavit requirement. 6 months ago, they were saying that didn't matter. And so in a height of hypocrisy, we now have the city solicitor's office here saying, strictly construe that. But if you look, all it talks about the circulator statement in section 2 is that it was, the signature thereof was made in the circulator's presence and is believed to be genuine, or the person it purports to be. The next sentence says, each signer of a petition shall sign his or her name, address, and date of signing in indelible ink or pencil. That's the person signing the petition that you have to have the date, which is the standard law in Ohio. So when the city comes in here and says, 6 months ago, ignore the affidavit, now they want to write something into section 2 that's not there. All section 2 says is it's got to be attested by the circulator that they witnessed it, and those signatures are that of which it purports to be.
Mr. Hartman, you're referencing, you're previously appearing before the board challenging Mr. Piraval's petitions for mayor, correct?
Oh, correct. And the
Yeah.
city of Cincinnati filed a brief with the Ohio Supreme Court in that case, saying ignore the affidavit.
Ignore that part of it.
Mandate that is
Yeah.
explicitly in the charter. That is hypocrisy for a city attorney to come in here today and do a 180.
Thank you.
Thank you.
Thank you.
Hypocrisy is a strong word. Politics is not, however.
That's right.
But when you're a lawyer, I expect you to be consistent as
Fair.
a lawyer with the law.
I'm agreeing with you, Kesh.
Well, I think not just as a lawyer.
I'm agreeing
but-
with you,
But
yeah.
any professional, you have to be consistent, no matter what field that you're working in. Do you have any comments? Ms. Poland, any point of clarification regarding the process?
No, I think for the records, that there were 23 part petitions that did not contain the date in the circulator statement. If the board chooses to accept those part petitions, then Mr. Brinkman has sufficient signatures to appear on the ballot. I don't know that that has been stated before.
Thank you. Thank you for that clarification. Yes, Mr. Mallett.
How many of the part petitions included a date?
I do not have that number. 23 did not contain the date. The remainder that were submitted did.
How many were submitted?
Just a minute.
Well, while she's getting that information, can I ask we haven't heard from our legal counsel at all on this. Obviously, we've heard from two different parties, but the person whose advice carries the greatest weight on this board should be heard, I think, Mr.
I
Stevenson.
agree. Mr. Stevenson?
You have a question?
Sure, your advice as it relates to the circulator statements lacking a date.
I think it's important to look at the whole picture. State law does not require a date on the circulator statement. The only purpose of the circulator statement is to obtain the evidence that the circulator witnessed every signature and that they believe that the person who signed it is who they purport to be. Those are the important items. The Supreme Court has, on many occasions, told us that we are not to look at technical violations in determining whether or not a petition should be accepted and whether or not a candidate should be placed on the ballot. A missing signature is not material, or a missing date is not material. A date that predates the signatures on the part petition is material, because that would be evidence of fraud, and that would be evidence that the circulator was falsely swearing. But the fact that the circulator's statement does not include the date, I don't think is material to these petitions. I did have a conversation with the solicitor's office. I can't remember whether it was Emily or not, but we did talk about when those dates become material, and she relates that the date is material when dates appear on the part petition after the circulator statement dated, and that's correct. Ordinarily, we would not accept the entire part petition in that circumstance. There are cases out there where as Mr. Hartman has pointed out, where the date of the election has been found not to be material. But the overwhelming sentiment of the Supreme Court with respect to this is that we are to ignore technical violations.
So, and based on what your statement, I'm very concerned that we ask the city of Cincinnati for their opinion. And when we requested that opinion, they were very emphatic that that the signature, the address, and the date of the petition must be on the form. So as a board, I'm just concerned from a scope of what our practice and role is, because we requested this for the city of Cincinnati. It is applicable to the city of Cincinnati candidates, council candidates. So I'm not very comfortable with going against what the city of Cincinnati charter says.
Well, the bottom line is that the reason we ask is that it is the city of Cincinnati's charter, and we thought that it was important that they be allowed to weigh in on it. That's why they were asked, and that's why they submitted this letter.
And they submitted
To be
it
honest
at
with
our
you,
request.
I cannot reconcile Part 1 with Part 2.
Mm-hmm.
They are either both technical violations, or they are both require strict compliance. The 1,500 signatures, I think the argument could be made that the excess signatures is actually a strict compliance. I'm not prepared to say that. I think it's a technical violation, but I think the arguments could certainly be made that if you submit more than 1,000, your entire petition is gone. I can't reconcile these two. I think that all the candidates that are related to these two things should be treated the same. Either they both go on, or
I
they both
agree.
come off.
I agree. And based on what the city of Cincinnati has responded, you're either on or you're not on. So, and I think that's where
I was waiting till y'all was done, sorry. I wanted to speak after that.
we are talking right now about the missing date of signing in the circulator statement.
Yes, ma'am, and I think I'm on that list. My name's Tierra Powell.
No, your name is not on that list.
Actually,
She's next.
she's the one immediately below Mr.
Oh,
Brinkman.
Yeah, she's next.
You're next, but we're still trying to
Okay.
discuss this particular area. That's okay, honey.
Val, just a
Your
minute.
time will be up.
We're almost
son.
there. We're almost there.
So, again, when we start becoming inconsistent, then to me, that's problematic. From the way the city of Cincinnati's opinion is, that this is that we either are in strict compliance or we're not, which is exactly what you said. So, Mr. Mallory, you were trying to say something.
Well, I was just saying that since Cincinnati is home rule and we asked for their opinion, I heard the city solicitor say that it was strict compliance for that portion. And then when she spoke to the number of signatures, check the first 1,000, we determined that here what we do, how many signatures we're checking. There was precedence back when Curtis Fuller ran for mayor. He had 4,000 signatures. We didn't check all of them. We checked and he met the threshold and he was placed on the ballot. So, I mean, this is apples and oranges, but I mean, the first part, when you're talking about, we asked for an opinion, they're coming and telling us strict compliance, and then our council saying substantial compliance because of the Supreme Court. So I want to err on the side of,
Joe, I'm sorry, Mr. Mallory. I apologize.
it's okay.
I've known you a long time, and you've always been Joe, but
Yeah, I'm Joe.
That's a different story. The charter says that the form is substantial compliance. That's what the charter says. Obviously that there are some issues that are substantial and some issues that are strict. With respect to the signatures, that doesn't say substantial compliance, which is why I think they should be treated the same. Either all the candidates are on or all the candidates are off.
Thank you, sir.
That's my opinion.
Yeah, so I know the question on the table now is regarding Mr. Brinkman's sufficiency of his petitions. And again, I typically will get some of this in executive session. We've chosen to get our advice here on the record in a public meeting, and that's our choice, I suppose. But without putting words in your mouth, Mr. Stevens, it seems to me like the most defensible legal position for this board would be to find that his petitions were substantially compliant and that he should be allowed to appear on the ballot. That's what I'm hearing. Again, you don't have to agree. If you disagree, I'd ask you to speak up. But again, you'd be in the position to defend this board if counsel were to seek redress in the court, something that Mr. Hartman knows a little bit about. So,
Mr. Triumphilo, the bottom line on this is the Board of Elections is about having competitive elections. And, the default position that the courts have always taken is if there's any doubt, they go on. If there's any doubt about whether a candidate should be on or not, they go on. If there's not, that's a different situation. Obviously, there are strict compliance rules the candidates have to follow, and sometimes they don't. Regardless of how often they've been on the ballot, sometimes they just don't get it done.
Yeah.
But the bottom line is that we have been told on many different occasions that we are not to look for technical reasons to keep someone off the ballot.
However, we have always been consistent with saying if these particular areas are not covered or signed, we reject them because they're not in compliance. So I'm thinking about, this is not the first time we've had an issue like this. We've always been consistent in saying if you're not compliant, if you don't have the data like you're supposed to, or the signatures, you are not considered to be on the ballot. What's troubling and concerning for me is we have adhered to that in the past, and I don't think that we should change from that, because then we start becoming very inconsistent, which again sets up problems from my perspective as a board for us.
I don't know that we've ever rejected a City of Cincinnati petition because it was missing a date on the circulator statement.
Yeah, and to address that, I think actually we're being quite consistent with what we've done. Again, just hearkening back to the situation with the current mayoral candidate, Mr. Pureval, Mr. Hartman presented a very cogent argument that we rejected ultimately about the sufficiency of his petitions, because a particular provision of the charter, archaic as it may have been, still was on the books. And you probably want to respond to that, Mr. Hartman. But still, nevertheless, we were consistent in allowing him access to the ballot. So it's sad, but it's political season. I understand that the hint of politics here is strong to me. I mean, this opinion from the city came in about 10 o'clock on a Friday night. It's in, again, Mr. Brinkman is being, we're being told by the city to reject him, but, the other candidate we're being told to accept. To me, this board's got to act in a fair way across the board, and I think my position is clear as it relates to Mr. Brinkman. So at this point, I'm prepared to call a question.
Call a question.
You want me to move? I'll move then. I'll move that we approve Mr. Tom Brinkman to the Cincinnati City Council ballot for the November 2nd, 2021 general election.
Second.
Any more discussion? I would just say, before I cast my vote, I think we should be consistent. It's not a matter of politics, it's about consistency, and I'm certain that in the past, we have followed this guideline as well when it comes to the city of Cincinnati. So I do not support that motion. So I'll say no.
You call for the vote?
Call the vote.
I vote yes.
Yes.
No.
No.
I wonder, just on the question, having, I think the manual says we have 14 days to submit arguments. Again, having been down this path before, I'd be inclined, Madam Chair, to get our positions to the Secretary in a much shorter time frame. I think that
Absolutely.
we'll definitely agree, right?
Absolutely.
To try to
Quick as
get the
possible.
Secretary to chime in.
It's
So
possible, absolutely. All right.
Madam Chair, I don't want to belabor stuff. I do have evidence to support also, and I don't know, since we got a tied vote that's now going to be going to the Secretary of State. What I have is actually two affidavits from two of these circulators attesting under oath that they did sign their circulator statement on or after the last date on each part petition. I don't know, since it's, like I said, since this is now going to be submitted to the Secretary of State, if it would be in order to still proffer those two affidavits at this stage.
Mr.
Mr. Stevenson?
For efficiency.
I
for the
think
board.
we should probably wait till we get done with the rest of the list, because we have the exact same scenario with respect to Ms. Powell, and we probably should hear from her first.
And it seems to me like you're going to do an oral motion for reconsideration on Ms. Matthews, perhaps the same as an order, just to make your record on
Correct.
Mr. Brinkman.
My only concern is a 2-2 vote.
Yeah,
Really,
there's
the board
there's
hasn't
been no
made a
rejection.
response.
Yeah,
There's
right.
been no rejection.
Well,
That's
the
my only
board
concern.
has made a response, and our response was 2-2, as you observed. So I think now we need to go to the next person. I've heard your
Well,
discussion.
my only concern is it in order to make a motion for Mr. Brinkman reconsideration? I can address that with Mr. Stevenson.
Kurt, that's something the board can consider, and in due course, but I think we need to get through this list first.
Exactly. Thank you. Next, City of Cincinnati missing date of signing and circulator statement and residence and nominating section. Member of council at large, a 2-year term, Ms. Powell. Comments, please? Comments only, yes.
So the only thing that I wanted to say was when I have documentation, and I know you won't see that right now, that I have received 2 calls that, when they called me about my petitions.
Can you speak up just a little, right
Yes.
into the microphone? Thank you.
They called me and told me that I made it on the ballot, and we talked about it, and I said, okay, thank you. They called me back almost an hour later and said, well, there has been an oversight that I actually was missing the date. At that time, I said, so what do I need to do? They said nothing, that they would file a recommendation that the board normally follows so that I didn't need to collect signatures. So I'm just saying that I think that I should be able to be on the ballot because at that time, if they would have not given me guidance, I would have been able to go back out and collect signatures, but the staff did give me guidance that it would be okay.
Yes. Yeah.
Thank you. Ms. Poland, thank you very much. Ms. Poland, can you respond, please?
As far as Ms. Powell's petitions, there's 2 issues. First is the missing date in the circulator statement. There's also several part petitions where the residence was not included in the petition of candidate. If the board would vote to accept those with the missing date, then Ms. Powell would have enough signatures. If the board does not accept the part petitions with no date in the circulator statement, I believe we would need to review whether or not there's enough signatures if the board would vote to accept the part petitions where the residence is not listed.
So we don't get to the second question if we answer the first, right? Is that a fair? Yeah. So
Correct.
if we were to vote, at least the 2 of us vote exactly the way we just voted for Mr. Brinkman, you wouldn't even have to touch the residency question because there'd be sufficient
That's
signatures.
correct.
Very good. With that then, I don't need, Mr. Stevenson, I assume your opinion's the same here as it was before?
It is.
Yeah, I'll move that we approve, go ahead.
That this is a technical violation and it meets substantial compliance to be accepted to the ballot, correct?
Correct, on the issue of whether or not the date in the circulator statement, yes.
Okay, thank you.
I'll make the motion. I'm certainly, the debate can go on, but I'm going to move that we accept and allow Ms. Powell access to the ballot.
What's your vote?
Second.
Second? All those, opinion, yes, no?
Are you calling the vote?
Calling the vote.
I vote yes on my motion.
Yes.
No?
No.
Thank you. The motion carries.
Actually, no,
Votes
Madam
count.
Chair, it
The
did
votes
not
count.
carry. Yeah.
The votes count. All right. Next, on the review, submitted part petitions comprising of more than 1,000 signatures. A member of council at large, 2-year term. This is where Mr. Harris was speaking, or came up to speak. Yes, sir, can you again come to the microphone?
Morning,
Can you
everyone.
speak clearly into it so we can hear you, please?
My name is Rob Harris, candidate for Cincinnati City Council. I have 2 points. Thank you all for taking the time to even consider this. I observe 2 points. This is my second time submitting petitions, and just hearing everything in a room. The first count was 460. It was 7 pages that was weighed out due to circulating. So if those 7 pages were considered, hearing the points and the councils that's representing others, then those would be valid. However, I was told I had insufficient signatures at that particular time. So what I did is went back to the drawing board and went out and got more signatures. And my case is that I submitted over 1,000. So I was told I had 520 valid signatures at the second time around. So we have a case in front of us that I submitted more, but they threw out and only counted, the situation Curtis Fuller, only counted 1,000 and didn't count the rest. And I still had enough to qualify it as sufficient valid signatures. Thank you.
Ms.
Mr. Harris,
Poland?
I can't not say that's incredible that you went out and got that many more, having many of us been part of that process, so you're to be commended on the, will, but
Absolutely.
it's a heck of a lot of work, which is why I'm going to support you being on the ballot, not just for that reason, because I think the law
Well,
provides for it.
And I think what he has just shared is, if you don't make it the first time, then you go back the second time. And that takes a lot of consistency and also concern. So, Ms. Poland, can you clarify that for us, please?
Yes, Mr. Harris submitted 1,556 signatures to the board. Staff reviewed the first 1,000 filed, and based on that, staff found 522 of those signatures to be valid. 500 is the number required.
Your
Yes.
opinion?
My
This time, it probably agrees with the city's view.
plain fact of the matter is I think this is also a technical violation. Whether we counted them for Curtis Fuller or not is past history and an entirely different board. But the bottom line is that I put this in the same category as what I talked about with the missing date. I think this is a technical violation, and I think that Mr. Harris probably should be on the ballot.
Is there a motion?
I'll move that we approve Mr. Rob Harris to the ballot for the November 2nd, 2021 general election.
Second.
Call for the vote.
All those in favor?
All those in
Aye.
favor?
Aye.
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 Thank you.
Motion carries.
Congratulations, Mr. Harris.
Thank you. And next is City of Cincinnati candidate request name on ballot.
Yes, this particular candidate, staff reviewed the petitions, found the petitions to have the required number of signatures. The question before the board is how Mr. Hurd should appear on the ballot. He's requested to appear using his initials, K.A. Hurd Jr.
That's never been a major issue here. We've allowed that, Mr. Stevenson.
The state, the Secretary of State has said that the candidates are permitted to use any natural derivation of their name, and the first two initials of their first and middle name are natural derivations of their name. I don't have any issue with that. In fact, we talked about this ahead of time, whether or not it would even be presented to the board.
But since it's here, I'll make a motion, and we can still debate. I'll just make the motion to put it on the floor. I move that we approve Mr. Kenneth A. Hurd Jr. to appear on the ballot as he's requested as K.A. Hurd Jr.
Second.
All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you. Thank you very much. Next, we've gotten through that list. Let's move next to certification of November 2021 general election write-in candidates.
Yes,
Poland.
you have the list of write-in candidates that have filed for the November 2nd, 2021 general election in your packet, and staff recommends certification of those write-in candidates.
I'll move approval of the write-in candidates as listed on the report given to us by staff.
Second.
Any more discussion? All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That motion carries.
Madam Chair,
Yes.
before we go, Ms. Powell, Ms. Powell there was a 2-2 tie regarding her being on the ballot. I just want her to hear what's going to happen next with respect. Just
so you know.
You can just stand right there. It's just so you understand, the board split 2-2 on whether or not you should be on the ballot. Mr. Triantafilo and I both voted to put you on the ballot. Our chair and Mr. Mallory voted to reject you from the ballot. We now have to present to the Secretary of State a case for you to make the ballot. They will argue against you making the ballot. That will be presented to the Secretary of State in 14 days on a technically we have to report to them within 14 days. It will happen before that. And then the Secretary of State will make a decision, inform us, and then you will be informed by this board whether or not you make the ballot. If there's anything you have relative to this situation, let us know. But I just wanted you to understand what was going on before you left. Do you have any questions? I'm sorry, I saw you leaving. I just, most people don't understand the technical nature of these things, and
Yeah, no, I don't have any questions. One recommendation would be that the staff not give guidance, because part of the reason for me not going back out to collect signatures was because the staff here gave me guidance that I was accepted and on the ballot.
Okay.
And that the board would follow their recommendation, which obviously didn't happen today.
right, well, that's a different matter than we have
Yes.
specifically here, but I just wanted you to understand, so,
Okay.
thank you. I'm sorry to yell at you as you're
No, that's
walking out in
okay.
the hall, but
Thank you.
Could you,
I don't know that that would be proper at this point.
no, Mr. Mallory was going to.
I was going to ask staff, like, when candidates turn in their petitions, we don't, that's not our practice, is it? We inform them that they made the ballot?
No, what our practice is, once staff has reviewed the part petitions, we will notify the candidate that staff reviewed the petitions and whether or not staff found there to be sufficient petitions, but that it's the board who certifies and makes that final determination. But it sounds like Ms. Powell is giving incorrect information, and that's something the deputy director and I will look into.
Yes, she was given that information. I was there with her. My name is Lisa Hyde Miller. I'm a community relations coordinator, but also a trustee for the East Westwood Improvement Association. And when she was given that information, I was right there with her. She was told that she made the ballot. There was one paper that didn't have the signature, the date on it. One paper. And that she had the amount of residents and everything was approved. So I was there with her, so I'm her witness for that.
Thank
We-
you, Rodney Christian, President of East Westwood Community Council. So I really appreciate you. I walked out and lost wonders, so thank you for that. It makes me feel more comfortable that this is shut the door, whatever. Thank you so much. Appreciate that. You're welcome.
Thank you.
Wait a minute. Did you want to say something, Mr. Mallory?
No, I'm good.
I just want to just also share with you all, it's not 2 against 2 or anything like that. We are following the guidelines that we have established and have worked under ever since I've been on this board. Also, any discussions that you heard here that we voted on was in relationship to following the City of Cincinnati Charter guideline. So it's not we against you or we against them. It's nothing like that. We have a fiduciary responsibility to follow the guidelines and the law as it's been presented to us by the City of Cincinnati. Thank you.
Okay, thank you.
Madam Chair, I, with all due respect, I beg to differ. I mean, this issue with respect to Ms. Powell was not addressed by the city solicitor's office. Our lawyer, who we rely on regularly and have for years, advised us that this was not a material defect, and she was substantially in compliance with the rules and should have been on the ballot, period. Thank you.
Thank you. God bless you. Next, basically, is certification November 2021 general election charter amendment filed after August the 4th. Trying to stay focused on where we are.
Sure. There was one charter amendment filed with the board since you last met. That was from the City of Cincinnati. It was by petition. Staff recommends certification. There is in your packet a letter that we received from Paul DeMarcos. I believe he is present, regarding the ballot language on this particular charter amendment.
Okay. Mr. DeMarco, could you step forward, please? Yes, sir. Can you share with us your concerns?
I think the letter speaks for itself, Madam Chair, and we will stand on the letter. Thank you.
Thank you. Do we need to, just a moment, I'm still in the middle of processing something. Is there anything else we need to say regarding this? Mr. DeMarco, for the record, has spoken, and I'm pretty sure he's following what his letter indicated to us. and we accept, now, we have to, Mr. DeMarco, could you just one more time? You said your letter stands for itself. Can you just, is it appropriate? Can you just give us a brief overview of what you want regarding the ballot language?
Madam Chair, with all due respect, it's been pointed out that you have counsel. I am counsel for the individuals I represent. And in the letter, we laid out numerous deficiencies in the ballot language that you received from the city.
Okay.
It is the duty of the board to comply with state law in adopting ballot language, and I think you should, with all due respect, rely on your legal counsel for any advice with respect to specific language and concerns.
Thank you.
Thank you.
To be clear, too, for the record, and maybe others haven't seen your letter calls on several parties, as well as the board, right? It's aimed at city council and other parties in this process, so it covers a lot of territory. Is that a fair summary?
Yeah, it was addressed to the city solicitor, it was
Yeah.
addressed to the mayor and the members of council who approved the ballot language
Right.
that we are challenging in the letter.
Very good, all right. Thank you.
Thank you. Thank you,
Madam
Mr.
Chair, the only thing I'd say is I believe, as Mr. Hartman rose to speak, he represents, if I'm correct, Mr. Hartman, the people who, the committee that was formed to put this on the ballot. So for that reason, I think it's appropriate. Since Mr. DeMarco has submitted something in writing challenging the ballot language that we hear from somebody, from the other side.
I agree.
Yeah.
Thank you,
Mr.
Madam
Hartman.
Chair. And I would note, Mr. DeMarco sends this letter out, I think, Friday, did not give the courtesy of even sending it to the committee. And so we're kind of playing catch-up in terms of his arguments that he was making there. But I think if you look at Supreme Court precedent, the standard is that the ballot language must be neutral. It cannot present arguments that amounts to a persuasive argument for or against the measure. I think a significant amount of what Mr. DeMarco is arguing for in terms of ballot language really seeks to putting spin or nuances or potential legal issues down the road as opposed to simply saying, here's what the ballot language says. I think the City Council did a fair job and a decent job in terms of presenting it in the legal standard that should be there. And what Mr. DeMarco simply wants is trying to put political spin on the language, which is impermissible and is prohibited under state law.
Thank you.
Keep the language that the council proposed.
DeMarco, I would, under ordinary circumstances, I think you get a rebuttal opportunity since you were, nothing, you're waiving that right? Okay, well, to the extent that it's a right, but.
Okay. Any other discussion?
Madam Chair, I will note that staff has drafted the ballot language using the language submitted by the city of Cincinnati.
Okay.
With that, then, I'll move that we approve the ballot language as it's come to us from the city, which is our typical practice here.
Second.
Any more discussion? All those in favor?
Aye.
Anyone opposed? Anyone abstaining? That language has been approved. Thank you very much. Next, appointment of precinct election officials. Ms.
Yeah.
Pollen?
Yes, in your packet, you have a list of the precinct election officials that staff recommends the board appoint, and then also allow the board to have the authority to fill vacancies as they arise in those positions.
I'll move that we approve the PEOs as presented to us by staff, and also allow for the authority of the board staff to fill those precinct election officials openings as they arise as we move toward election day.
Second.
I just want to say before we call for the vote, I want to thank all of you all. Ms. Poland, Mr. Linzer, the staff, for the great work that you did to get us here. As you know, I've been asking almost every meeting, where are we with this? Where are we with this? Not only this, but also the polling locations. And, I always say it takes a team to make a dream work, and this is a great team here. Everybody, thank you for getting us to this point where we have this document. Again, all those in favor? Aye. Anyone opposed or abstaining? That motion carries. And again, thank you all. Next, authorizing amendment agreement between the City of Cincinnati and the Hamilton County Board of Election for associate membership in CAGES and the sharing of data. I am so familiar with CAGES, so when I saw this here, I just said, wow, we're finally moving forward. So Ms. Poland or Mr. Linzer, kind of give us an update on what this means to our audience.
Sure. In 2012, the board first entered into an agreement with the City of Cincinnati to provide data to CAGES. Basically, for the last 8 or 9 years, we provide CAGES with our precinct boundary lines and polling locations, and then CAGES maps that as part of their system for the public. With the redistricting coming up, staff has done some due diligence in looking to upgrade our current GIS mapping software. And we found that it would be best if we amended our agreement with CAGES that would allow us to actually use the software, the mapping software, the GIS software that CAGES uses. And then with that, we'll also be receiving support for CAGES with that. And basically, it's at a cost that eventually will be less than what we currently pay for our current software license. So that's what this resolution would do. It would allow the deputy director and I to amend that agreement with the City of Cincinnati pending approval of the agreement from the prosecutor's office.
I'll move that we adopt resolution number 21-004.
Second.
All right, any more discussion? All those in favor? Aye. Anyone opposed or abstaining? That motion carries. Thank you very much again, moving us forward, as always. Next is resolution authorizing execution of equipment delivery contract. If I recall, this was a point of discussion in our previous meeting or two.
Yes, just to refresh the board's memory, we had gone out to bid for equipment delivery in early 2021. At that time, we only had one bidder. We entered into a contract with that vendor. A few months later, the vendor notified us that he had actually made a mistake in his interpretation of the bid and in the contract, and that he would not be able to fulfill that contract. So we went out to bid again. We received 2 bids. Staff did our due diligence in checking references from the bidders, doing a site visit, and we are recommending that we remain with our prior vendor of Weil Thilman. And this resolution would give the deputy director and I the authority to enter into a new contract with that vendor with the approval of the prosecutor's office.
Any more discussion?
Is it just, they just need more money, frankly? Is that?
Yes, the original contract was bidded per precinct, and the bid actually called for a per polling location price.
Okay.
And that's been corrected with the new bid and the new proposal, as well as the new response to the proposal.
They've done it for us before. We're confident they're.
Yes, yes, and that's what the second vendor, after checking the references and doing a site visit with staff, it's our recommendation to stay with the vendor we've been using.
I'll move adoption of resolution 21-005.
Second.
Okay, any more discussion?
I just want to thank staff for their due diligence and making those site visits and digging a little deeper on those who bid.
No doubt. Agreed.
And, you know, not only that, but in spite of all of the petitions, all of the signatures that they had to check, everything that you had to do in the past 60 days is just phenomenal. So, again, kudos to you all for the great work that you continue to do. Any more discussion? We have a motion. It's been seconded. All those in favor?
Aye.
Anyone opposed or abstaining? That motion carries. Thank you very much. Next, discussion regarding registration voting anomalies. Ms. Poland?
Yes, you have a summary in your packet. This has come to staff's attention regarding voting and registration status of 2 currently registered voters in Hamilton County. The first is registered to vote in Hamilton County of January of 2008. She has voted in Hamilton County in March of 08, November of 08, and November of 12. Then this particular voter registered to vote in New York City in September of 16. She has not canceled her registration in Hamilton County. According to records we received from New York City Board of Elections, this voter has voted in New York City in November of 16, November of 17, November of 18, June of 19, 11 of 19, June of 20, and then voted by absentee ballots from Hamilton County in November of 20, and then went back to voting in New York in June of 21. So although the voter has not voted in the same election in two different states, there appears to be some questions regarding her residency.
Sure does. So, yeah, so it's clear. This is a person who registered here in January of 2008, consistently, fairly consistently voted in 08, and then voted again in the presidential of 12. Looks like they definitely voted in both presidentials in 8 and 12, and then moved to New York in 2016, or at least it looks like they did, because they registered to vote in New York, and then they voted 6 times in New York, including in June of 2020, and then cast the ballot here in November of 20, only to have gone back now to New York and voted just this past June in their primary. That stinks. So I think we should investigate it. My view is that we send it to the prosecutor's office just based on that. I mean, again, it's not our call to prosecute, but it's certainly, there's enough evidence from me, at least at this juncture, to send it over to a qualified criminal investigator to see if this person cast a ballot in Hamilton County out of some level of convenience rather than actually living here. Convenience is the wrong word, by the way, with some malicious intent. I'm not suggesting they did or didn't, but it's possible they did, so I think the prosecutor ought to look at it. That's my view.
Yeah, I don't disagree. But everything seemed to be in order until they got to 2020.
Yep.
And I guess they didn't re-register when they came back in 2020 and voted?
No, the voter remained on the registration rolls because the supplemental process was suspended for so long because of lawsuits. So the supplemental process was not conducted for years. She was queued and was on the last chance notice in 2020, but then by voting in the November of 20 election, that kept her registration status alive in Hamilton County. So she's still registered in Hamilton County currently.
So it's clear that this person's kind of been bouncing back and forth. And I agree that there's suspicion here. This is not the type of person that we want moving it back and forth between New York and Ohio. I do agree with referring it to the prosecutor for further investigation.
All right, so I'll move then that we refer this particular voter, last name Jang, to the prosecutor for further investigation.
Second.
Any more discussion? All those in favor? Aye.
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 Anyone opposed? Anyone abstaining? That motion carries.
Before we move on, in terms of this person wanting to cast a ballot potentially in the November election, I mean, the board can sua sponte challenge a voter, can it not, Mr. Stevenson? I mean,
Yes.
So what I'm suggesting is that perhaps we put on a voter challenge to this voter that they established that they're properly registered. How does that work again, Sherry? Remind us that it would be a provisional ballot if we challenge them at the polls?
For this particular voter, I believe that's the way we would have to handle it.
That's generally the way you handle it when somebody's changing residences.
Yeah.
And then it would be up to we, as the board, to research and
Yeah.
and then,
Well, what would happen is if they showed up at the polls, they would have to fill out an affidavit, which
Right.
would provide proof that they lived at that location on the day of the election.
But also, if they last voted in New York, June of this year, couldn't we send them a letter to cancel their registration here in Hamilton County?
oh, that's in it.
That's always been, the more sort of heavy-handed. I don't mean that in a negative way. I just mean, I'm prepared to go there, is what I'll say. But
I mean, it's been a couple months. They just voted. So
Yeah.
if they're voting there now, this kind of put them on their radar that, hey, you might need to cancel your registration in Hamilton County.
So you're thinking we send a letter and then maybe get a report back before we do it?
Yes.
Yeah, okay, fair enough.
I
Yeah.
agree.
Yeah, that's fine.
That way there's no surprises.
Do we alert the voter that they're being submitted for investigation? Or no, probably don't want to do that.
Typically, we do not.
They were doing it in a public meeting, so.
Okay.
All right, so how about then? Are we talking about just a letter that comes from the director and deputy that says, we've noticed this anomalous voter behavior and we're prepared to cancel your registration?
That's it? Simple and sweet? Yes.
I'm sorry, Madam Chair.
Yes.
I may have lost something here in the process, but, I mean, it seems clear to me that this person has voted in at least 2 states that we know of in 1 calendar year, and then came back here and then went back to New York and voted again. Are we going to not suggest an investigation?
No, we did.
Oh, okay, I'm sorry. I thought we had moved past that to
No.
just send a
No,
letter.
no, you referred.
Never mind. I'm
you-
good.
You referred her to the prosecutor's
Got it.
office for investigation, and
I'm good.
Okay.
Sorry.
All right. Next person?
Yes, the second voter on your list, somewhat similar situation. This particular voter registered in Hamilton County in October of 2018 and voted in Hamilton County in the November of 18 election. The voter registered to vote in Braham County, New York in August of 20. Records from Braham County indicated that Ms. Jones has not voted in Braham County, but she did vote in Hamilton County in November of 20 after registering to vote in Braham County, New York on August 20th.
That one seems a little less egregious only because she
I
hasn't
agree.
voted yet there. I still would be in favor of maybe a letter, maybe a little less tough, just, I don't know. What's the pleasure of the board? I'm open. I think we just need to guard against her casting a ballot here if she's living in New York. And now that we have some sense that she is, I could have been a college student who, ultimately came home. You just never know.
I think a letter would be appropriate because, they may not be up to speed on the current laws and things like that. And I agree with you, it's not as egregious as the previous one.
A simple letter explaining where the issue is sufficient. And I agree, we should send a letter to the particular voter.
Where they last voted in
in
November of last
20.
year.
Right.
So a letter simply asking the voter to confirm her residency in Hamilton County?
Yes.
And maybe suggest she cancel her registration in New York if she's back here. I mean,
Correct.
just so it's,
Just for clarification for not only her, but for we here at the Board of Election as well.
yeah.
Thank you. Okay. Next, discussion, social media update. Sherry, Ms. Poland?
Yes, we would like to look at adding 2 new platforms to our social media. We currently are on Facebook, Twitter, and Instagram. We'd like to move forward with, at this time, with the platform Nextdoor. If you're familiar with that at all, but we've had some success just having employees using their personal accounts and getting the word out and recruiting poll workers through Nextdoor. So we'd like to have a Board of Elections account, not only to use that to disseminate information regarding voting, but also to recruit poll workers. And then it's been recommended by our digital communications staff to look at having a TikTok platform, and so the deputy director and I would like to explore that option a little more and report back to the board.
I think it's a great idea.
Everybody's doing TikTok.
You guys want to do a dance challenge or something?
Yeah.
But maybe
Not
I will
off
take
the
my,
table.
yeah,
Well,
I'll
it
take
was-
myself out of that one.
Oh, I'd take both of you. You
With
can't
the-
take
with-
yourself out, you both have to come in. I think it's great that we're looking at entities like Nextdoor and the TikTok. A lot of people do participate in those particular apps. I think it's great, so,
There's been some angst about the TikTok application, which, by the way, I have and look at. So the fact of the matter is, though, I think the staff should do some due diligence about the security of that. I to the extent somebody from the public is watching us and sees us launching into TikTok and all the angst around elections and election security, I just think it's something we should look very carefully at so people don't believe that somehow, one of our computers has this application that I think was the subject of some alerts that came out of the State Department, et cetera. Just stuff I've seen in the news media. But before we put the official sort of seal of approval on TikTok, I would want to know more about it.
Yes.
That's my view. Yeah.
That's a good point. Okay. The board have any other business? Before I ask anyone from the audience to comment?
Madam Chair, I think just to cross our Ts and dot our Is, our policy requires that the board approve new social media accounts. So if we could just do an oral motion to give the director and deputy director authority to pursue both of those endeavors, I think that would probably be necessary.
And I would like to also add what we also talked about, making sure that there's, once you do that, that we continue to dig deeper, looking for any, to avoid any security, glitches. Need a motion?
I don't have any problem with the deputy director's suggestion of a motion. My motion is going to be clear, however, that the ultimate decision to go forward with that social media, I think, should be voted on by the board. I'm not prepared to give blanket authority yet to anyone on the staff without reviewing it. So I guess my motion will be that that we ask our staff here to move forward on investigating the possibility of expanding our social media footprint.
Second.
Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion.
I voted aye for the record. Yeah.
Aye. Okay. Anything else? Now comes the time when we also ask for audience participation. If you have any questions or you'd like to address anything with the audience. Yes, sir. Could you please step to the podium and share with us your name and your address, please?
Good morning. My name is Joseph Edgel.
Could you speak put the microphone a little bit closer to, there we go.
Good morning.
Mm-hmm.
My name is Joseph Edgel. And I would just like to know if anybody here has heard of anybody that proposed a bill or anything to do with auditing the 2020 elections for the state of Ohio. Does anybody know of anybody?
We audit the election here in Hamilton County after every cycle. We do it in a public meeting. We randomly select precincts. We hand count the results that come out of the machine and the paper ballots to make sure those match. And we do that in every cycle. We also do it in close elections that are inside the, inside the
Yeah,
half a percent would be the threshold. But elections that are close, we also hand count those as well. So there's a whole auditing process that we do consistent with law.
Does that have anything to do with the complete state? I mean, is there anything, a bill or anything any proposal to audit the 2020 Ohio state election?
Well, your question is a great question because it's we are in an ongoing auditing process all the time, and we do have a person here that works with the Secretary of State. Ken, could you address his question, please?
Yeah, I'm Kenny Henning with the Ohio Secretary of State's office. Thank you, Madam Chair. I will say, in Ohio, all 88 county boards of elections do that. RLA process that you did here after the. But yeah, we do.
I'd like to make a couple comments about the representation of our good people of the first district. I've had many friends and associates and people that I know just making comments about that, feeling that the first district is not being represented properly and has been in decline without proper representation for a long time, many. I just want to let them know that we expect more out of the representative for the first district than what he's obviously not been doing, not what he has done, which is what I heard him on the radio the first time this morning and it seems like he just pops his head up every couple of years and has a few comments. But I just want to tell everybody in the entire district that we need some new blood. We need 20 years, over 20 years is a long time. We need to clean house, get some new blood in there, somebody that can excite the base. That's about all I wanted to say. Just give everybody in the district my comment.
Thank you.
Thank you for.
Thank you very much, Jim.
Thanks, sir.
Thank you very much. Mr. Hartman, I saw your hands waved.
Consistent with our previous discussion, I would ask the board on behalf of Linda Matthews to reconsider its decision to reject her petition and to not place her on the ballot. As I indicated, I have about 1 or 2 minutes of testimony from her that I could proffer to the board, or let her present to the board, excuse me, by which I believe the case law supports placing her name on the ballot.
As we suggested earlier, but now would be the appropriate time procedurally, Mr. Stevenson?
Yes.
Sounds to me like what you're suggesting is the one time to present it, and that would be now.
Correct.
Okay, just procedurally, that's something that's acceptable to you and your client.
Correct.
Okay.
And and Ms. Poland might confirm, maybe, there was one part petition that was withheld. I'm not sure of terminology, but that was not counted in the tally because the number of verified signatures versus actual signatures on the petition varied. And it is my understanding that if this part petition is accepted, there would be sufficient number of signatures.
There was one partition that was withheld, but even if that part petition was included, it would still not give Ms. Matthews the 500 required valid signatures.
I believe she was only 14 short, if I'm not mistaken. Maybe we're talking theoretical then, but she was only 14 short, and there are more than 14 valid, if there are 14 or more valid signatures on that part petition.
There are not 14 valid signatures on that part petition.
I'm counting 15 marked indicate as by the board's checkers.
Do you have a copy of that?
I've got it. I mean, there's not one, unfortunately, the board didn't do their analysis, wrong address, right address. So I'm kind of lost in terms of what exactly a withdrawn petition is. Usually we check all the signatures, put the stamp, give it a petition number.
Typically, when a part petition where the circulator indicates that they witness less signatures that appears on the part petition, that is a part petition we cannot accept, and so staff does not check those signatures. It's a little different than the other categories of petitions where it's sort of a gray area, where it's not as outlined in the election officials manual as this one is, as though it can't be accepted. But after Ms. Matthews contacted staff, we did, the deputy director and I have looked at these signatures contained on the one particular part petition in question, and even if the board chooses to accept that part petition, it does still not contain enough valid signatures.
Can you indicate for the record how many valid signatures would be on that petition?
I believe it was 8 that we came to agreement with.
But we don't, at this stage, then, we don't know which signatures those are or not. Let me talk to Ms. Matthews for a minute.
Yes.
If that's the case, I mean, again, I'm kind of a little at a loss because there are no indications on this petition which signatures are or not valid. Please? Would you like more time? Probably, and that's what I'm trying to figure out. If the board, I mean, I'm just looking at the marks at the edge where they check some off and then an X some of them. I count 15 check marks, which I would presuppose as opposed to X's.
I haven't seen the document that you're referring to.
It's what I got from the board, but if I may.
Right.
That was the that was the part that emailed to me.
Right, you requested this document before staff had reviewed this part petition. As you'll see, there's no sticker, there's no page number at the top of the part petition.
Right.
And the marks that are made to the right-hand side of the column are not marks by board staff.
We do have a part petition with those marks on it now,
Uh,
and they're numbered, and the petition's numbered?
The petition, I don't believe, is not numbered, but we can get you a copy.
I'm going to then withdraw that motion for reconsideration pending review of this part petition, and within a day or two, potentially asking for reconsideration.
Yeah, unlike a court proceeding, it's your decision to withdraw it. I suppose for that reason, it's withdrawn. The only thing I would say is, let's work cooperatively to come to an answer quickly. When are we meeting again? Don't we have a challenge hearing or
You
something?
have a meeting on September 13th.
Is that too late?
Yeah,
Yeah.
yes.
So
Yes.
can you expedite that process so information in the final
I think you're going to get a court case over the charter language anyway, so the ballots probably would not be printed by then.
I got a point, like, yes, we are.
So the ballot, yeah, so in terms of ballot printing, it's not constrained by that. That's the only thing I would point.
We need to expedite this as quickly as
Agreed.
possible.
Agreed.
You should be able to expedite this and get this completed within the next day.
Day or two. Let me consult with Ms. Poland and in the next, later today or tomorrow, in which.
Okay.
My point is the board needs to reconvene. I'm wondering if we shouldn't just set another hearing today.
I am not available on Friday.
Okay.
Neither am I.
Neither am I.
Neither am I, actually. So, how does everybody look to come back, like on, I'm suggesting that if we pick a time and date, council has a deadline, we have a deadline that we can work on. So, I mean, I'm free Thursday I have a routine doctor's appointment. I'm happily will reschedule. So, Thursday morning works for me if it works for everybody else.
Ms. Poland, I'm just going to ask a question. Can you do this, can we stay over a little bit today, and can you guys knock that out?
I think it
While
would
we're
be best
here?
if we give it a day or two.
Why don't we do it on Monday, the 13th?
It would still, it puts an enormous amount of stress on staff who's already scheduled to work 12 hours a day the next however many days proofing the ballot. So
How about if we come
Thursday
back?
would work best.
I'm good on
Thursday
Thursday.
work better, or can we come back today? Let's say at 4 o'clock.
I can't do it today at
Oh.
4. I have court.
Okay.
We'll go let's go Thursday then. And
Thursday
like I
not
said,
work for the rest of the
we
board.
can
I don't
figure
want
out if
to
it's
create
going
a
forward or
headache
not.
for anyone. but-
What time did you say Thursday?
8:30 is our normal meeting time, if that works.
That'll work.
Chip?
I have to be out of here by 10.
Oh, that's fine.
That'd be fine.
I have to be out of here by 9:30.
Perfect.
Okay.
I do it early?
We should know by tomorrow definitely whether we're going to go forward with that hearing or not, so
8
I think it's good
a.m.?
to set it.
8 would be better for me. I have a previously scheduled call at 9.
We can make 8 work.
8 works for me.
8 a.m. works for me.
Yeah, I can do that.
Okay, so we would need to meet even if you all have communicated with the information and you decided not to proceed.
Seems to me like if it's your motion that will determine whether we meet. So we be able to let the board know if you're going to actually go forward with a motion for reconsideration. Maybe,
okay.
I mean, I'm not trying to put too much pressure on you, but by the close of business Wednesday, maybe, or?
By then.
Okay, so
Okay.
if he doesn't make a motion for reconsideration, we don't have to meet.
Okay,
The decision
that'll
will
work.
stand.
That's what I was saying.
But if you
Okay.
review then you've got, a day and a half here to do it.
And we had to notice the meeting, like, what, 24, 48?
24 hours, correct.
Yeah.
Okay,
So you're going to, just as a courtesy to the board, you'll let us know by the close of business tomorrow whether you're going to file your motion or going to proceed with a motion?
That is correct.
Very good.
okay, very good. Thank you.
The second thing, Madam Chairman, on Mr. Brinkman, and I'm not sure, and again, I raised it before, procedurally, how we want to do it. I do have, and what I would offer, if I did a reconsideration, would be 2 affidavits from 2 of the circulators with respect to part petitions 39 to 53 and 56 to 61, which, if those were valid, would take them above the 500 threshold. And I'm not sure if it's appropriate at this time for a reconsideration, but I think it's important to get everything in the record as there can be. So I don't know if Mr. Stevenson can give some guidance in terms of, since the tie vote is currently going to the Secretary of State, the petition has not formally been rejected yet, but would it be in order to at least proffer the 2 affidavits to the board at this time?
I'd like them.
And I'd ask Ben to reconsider the vote that was a tie vote. That might convince the 2 votes against certifying him otherwise. Again, I think just in terms of
Mr.
efficiency,
Stevenson.
timing.
I think in light of what he's asking you to take a look at the affidavits and determine whether or not that you would reconsider your tie vote. I think that that's probably okay.
So are you making a formal motion for
I am
reconsideration?
making a formal motion for Mr. Brinkman to reconsider. And as I indicated, in terms of that, I've got two affidavits for part petitions 39 to 53 for 1 circulator and part petitions 56 to 61. The affiants are Jacqueline Gooch and Pat Richardson, respectively. Both of them, with the part petitions attached to the affidavit, state that with respect to the statement of circulator on each of the part petitions attached hereto, I did in fact execute and sign the statement of circulator on each of the part petitions and did so on or after the last day of the signature on the respective part petitions. So,
And the dates are on there. Okay.
I attest that they executed it on or after the last date of the signature
Okay.
on each part petition. Those signatures would then take the number above the minimum number required to be placed on the ballot. This shows that the compliance was met, that the person did sign them, that they were signed after the last signatures on each part petition.
Okay.
And therefore, I'd ask the board to reconsider its position and to place Mr. Brinkman's name on the ballot. I think this is consistent with accepting affidavits in this context. There was a Cincinnati School Board case 2 or 4 years ago, I can't remember. Board did exactly this, accepted affidavits, found that was sufficient to remedy the deficiency and place the person's name on the ballot. So the precedent of this board is to accept it and to place the name on the ballot. Thank you, Madam Chairman.
Anything else?
Mr. Stevenson, are we now at the point, is this like a quasi judicial hearing? Since he's asking for reconsideration?
It's always been a quasi-judicial hearing because what you're doing is determining whether or not candidates are going to be certified to the ballot, and that's a quasi-judicial.
Correct. So was he submitting evidence, these affidavits here?
What he is submitting is evidence in support of his request for reconsideration.
Okay.
And this is the first time we've even heard of this. This is the first time we've seen it, so we need to consult not only with you, but also review what he's just presented to us before we make a decision.
That's correct. I think what he's trying to do right now is just kind of speed the process along. And in terms of your status right now is you're 2-2 on whether or not Mr. Brinkman and Ms. Powell go on the ballot. So if you want to accept the evidence and change your mind, that's fine. If you want to accept the evidence and not go forward, that's fine too, and rely on the 2-2 ballot, that's fine.
Because this is something he's just presented to us, from my perspective, he's presented it, we haven't even had a chance to look at it. I just say we proceed as we voted earlier.
That's the board's
That's my decision.
I'm open to seeing what he's presenting.
Yeah. I mean, the affidavits.
I'm open to seeing it, but my goodness, I'm not going to make a decision instantly just upon seeing this. I want to review what it says, and I'm not going to accept your affidavit just like that. I need to review it, I need to look at it, and then make a decision from there before I would even reconsider changing my vote.
I understand and respect that. I would just point out, Madam Chairman, that it's a 3-paragraph affidavit. I think the first paragraph says person's over 18 years of age and has personal knowledge. Third paragraph, which is the substantive one, basically attests that the person did sign those part petitions, which are attached. And then I think Ms. Poland can confirm that those part petitions contain sufficient number of signatures that would place Mr. Brinkman over the 500 signature threshold. So it's not a convoluted, it's not a complex affidavit. I think it's very simple and straightforward. To get the board to accept those part petitions, which again, Ms. Poland, if you might confirm that that would be enough. Those part petitions did get accepted, that would be enough to validate Mr. Brinkman's placement on the ballot.
I would just need to verify who the affidavits are from.
Got Pat Richardson and Jacqueline Gooch, and the part petitions actually are part of the affidavit that they actually circulated. So they test that they reviewed.
We would need to verify this. Ms. Poland and Mr. Linzer?
I think the timing won't be a significant amount of time to do that verification.
I would like to wait until it's verified before I make any decision. And it would be verified in a nonpartisan way, but that's important, like we always do. So I'm not, at this point, ready to make a decision until that's happened. Anything else?
Well, yeah, Madam Chair, yes. I think the first order is that we accept these affidavits as part of the record with respect to Mr. Brinkman's candidacy.
I thought we were already doing that. We're accepting it.
Well,
Do we
I
have to
don't
vote
know
on
if we
it?
need to make a motion probably to accept them.
Yeah, I would
Okay.
suggest that, and the question is whether you're accepting them as evidence or whether you're accepting them as a proffer at this juncture, I think.
I mean, yeah, it seems to me I will make a motion that we, as part of this motion to reconsider, consistent with council's opinion and recommendation to this board, and that is that on a motion to reconsider, at that juncture, we should consider evidence. As a matter of fact, I think you said earlier that we almost must consider whatever evidence is presented to us by reconsideration, so I think we have to accept the affidavits. So I'll move that we accept accept the new evidence that happens to be 2 affidavits in this situation.
Second.
All those in favor?
Aye.
Aye.
Aye. Anyone opposed? Anyone abstaining? That motion carries. All right. Any other business? Thank you.
Well, I guess the question is, when is the board then going to act on the reconsideration?
I think the
You know, if it
question.
takes 5-10 minutes for Ms. Poland to review, then we could probably recess for 5-10 minutes. If it's going to take 5 hours.
Mr. Stevenson, you were trying to say something?
I was. I mean, the question, I guess the question Mr. Hartman is asking is whether or not you're going to plan on trying to do that today, or whether or not you're going to send a 2-2 vote to the Secretary of State at this point.
I think because time is of essence, I think we need to move forward with sending the document, the proper paperwork to the Secretary of State.
You've made a motion for reconsideration that I think you're suggesting requires a board vote, and I agree. I think that we have to, I'm prepared to make a motion that we grant the motion for reconsideration as it relates to Mr. Brinkman. I would make it as it relates to Ms. Powell, but there's been no new information. My vote remains the same on Ms. Powell. But as it relates to Mr. Brinkman, I vote that we grant the motion for reconsideration and allow him to go forward on the ballot.
I would second that and comment that, you know, in my opinion, this is a ministerial act by us, that we're almost obligated to reconsider this once the motion has been made. We've accepted affidavits into evidence as a board already, and so I don't know how we cannot then pursue with the motion to reconsider, whether we do it today or we do it Thursday. You know, we can have that conversation, but along with my second, those are my comments.
As I indicated earlier, I am not wanting to make any statement until it's been evaluated that these are certified, that the signatures are verified. So, based on the fact that we're going to be meeting on Thursday, then that would be the time that I would I think that we should look at whether we reconsider or not.
So we're basically tabling the motion.
Table in the motion.
But the board will meet on Thursday regardless
Yes.
of what we do with this matter.
Sounds like it
right.
now.
That's
Very
right.
good, that's
Well,
fine.
I mean, are we tabling the motion, or are we just deferring the hearing until Thursday? I mean, we have a motion and a second on the table to consider Mr. Hartman's request. I think we need to deal with that and
I agree,
I'm
you need
saying-
to have a vote on the motion, but,
Can we table, I say table it. Can we table
Postpone
it?
it, further consideration until Thursday would be in
if
order
you,
under Robert's
look, the
rules.
bottom line, the bottom line is that there is a motion on the floor to grant the reconsideration. Unless Alex withdraws that motion should be voted on today.
If it's, in good faith, you're going to look at it and we can avoid a 2-2, I will withdraw the motion at this juncture just to allow you a chance to look at it.
I would
Fair enough.
appreciate that.
So I'll withdraw my motion and then,
Thank you.
and again, we reserve the right, of course, to bring it again. But my position's very clear and as it relates to her and to Ms. Powell.
Understand.
Thank you.
Thank you, Madam
I mean, as it relates to him, Mr. Brinkman and Ms. Powell, sorry. Yeah.
That's right. Okay, anything else? Any other comments? Yes, sir?
Just want to make a comment. I'm
Can
representing.
you, again, share us
right
your
here.
name again?
My name is Nathan Ayah Israel. Making a comment. I came here on behalf of the parental rights movement. There's a lot of people going through parental. Yes, there's a lot of people going through a lot of misery, and that's why it was very easy for me to get the signatures that I garnered because of 2-for-1 kids taking children and making money from it, separating fathers from their children, and putting them on child support, keeping and alienating them from their children, because of state funds that they're gotten from alienating children and taking children from their parents. There is no place for those people to go to get any information on their rights in regards to not letting them in the house and things of that nature without a search warrant or suggesting them to a relative instead of going into the system. One thing I do need, because I have some people that I have to report to because of this. You have something tangible for me to have that states that that these, because I could show many different ones where it was just blatantly the address was there, but it said the address wasn't there. Is there any way I can have something tangible for the people that I have to report myself to? For my particular board and things of that nature, and also the person doing my petition, do they take an oath? And can I get their name? And do they take an oath and can I get their name? And do I deal with the board in regards to the? I don't want to. Do we want to use the word fraud? Do we want to use that? Or do I deal with that person on an individual basis in regards to this negligence? Also, I guess I'm gonna. Can a voter challenge? I know you're talking about people challenging the board. Can a voter challenge the board in regards to what's going on? Because like I said, I don't even think I'm very grassroots. Obviously, I don't have the backing of other people, and I feel like a lot of people who are going through misery in Cincinnati are going through these particular issues where they want someone to step up. They want someone to be the advocate for them because they have got their children stolen. Is there any way that we can sit down and get this thing resolved, or where I can show, like I said, because I have the same thing. I can show up on Thursday with all of them, because I only have 8 pages, and those 8 pages have at least 20 different instances where it was said that the signature didn't match the address, and it blatantly did. So I don't know if that's just fraud. I don't know if that's federal, but that's blatant fraud. And we, that's the reason for what's going on in our country today, because of all this fraud and putting somebody who's illegitimate inside. But that's what I want to say. I really just need some help and understand what's my next step. Do you guys have any steps for me to get to understanding?
Sir, what I would like to suggest is, let's start first with your meeting, scheduling a time to meet with Ms. Poland and Mr. Lenzer, so that they can sit together and go over your petitions. Would that be appropriate, Ms. Poland? And that may, at that point, any questions that he has asked, at least visually, you'll be able to show him where some of the concerns were?
Well, it sounds to me like he's asking what his next recourse is, and I think we rejected, and now he can appeal and file for,
He can certainly
Hearing?
file an expedited election case in the Supreme Court of Ohio. The other thing is, he's also asked for copies of the petitions with the notations on it. I think you probably are obligated to give that to him before he leaves today, along with a key explaining what the situation is.
And I think that, and correct me if I'm wrong, in error, you're asking for that, plus getting a better understanding from our perspective, where your questions were and who did what and when they did it and what the outcomes look like.
No, yeah, well, I really just want the particular, do they do an oath of office when they do this type of particular thing, where they go and they check and see the signatures of the different people?
all employees here are sworn.
Oh, yeah, okay.
They take an oath.
Yeah, because I want to make sure, because like I said, it's blatantly a lot of different ones where it was just obviously it's the signature does match the address. That is their address. And it really, and when you look at the petition, I really couldn't even figure out what the names of the people were because they were signatures. So only the ones with the names that I can actually look and see what their names was. Now, then I typed those in and I got a whole bunch. Not to mention all the signatures I couldn't even read. So it's blatantly so many of these that are just wrong. And actually, I had 367 that they put on my thing that I had, right? And 380, but that the signature didn't match the address, 380. That's
Well,
I
sir,
only need less than a third of them
Sir, what
to
I
be on the
think,
ballot.
now correct me if I'm not hearing you correctly. You're asking for clarification. First, are all the individuals sworn to take an oath? Yes. But there are other questions you're asking legitimately regarding that particular, your petition. So I think most of them could be answered and addressed by sitting down like we do with everybody else, just to go over and review those and show you where the errors were and what you can do to correct them. For example.
Well, you are correct. Like after it's shown
Yes.
that it is,
Right.
I can update it and say, yeah, I had this many votes and not that many votes because the guy
Right.
was not doing his job, and I don't understand why somebody would do that. Why would they? Why, and that's why I would really like his name as well and see
Well,
what's really
why
going
don't-
on
can-
with this.
is
I want to
it-
sit down with him that day, not
Is
just.
it Reese, Ms. Poland and Mr. Lenzer, can you sit down with this gentleman and go through his petitions? I know the schedules are crazy and it's tight, just to address some of his,
Whatever. It doesn't
issues.
matter.
Madam Chair, at this point, since the board has already voted to reject the petitions, I think the most prudent course of action would be for us to follow the procedure outlined in the election officials manual, which is the candidate can request reconsideration.
okay.
And if he has specific signatures that he thinks the board should have counted, he could include that in his request, and we can take that up again on Thursday.
Well, we can do that. I just thought maybe there would be a simpler way from the way he's requesting. But if we go that route, then that's the route we would go.
Yeah, Mr. Lynch, it seems
I
prudent
think
to me.
that's, I agree.
But
I
I'm
would
just going to understand it. So when I do prove that that they do match, the address does match, will it be updated, or are you saying I just have to try and hopefully you all pick it up? But what I'm saying, I really would like to make sure that I have the correct amount, because like I said, I did correct amount of, it's a signature match the address, which like I said, I can show you right now, 30 of them right now. But it's a signature match the address. Can I have that updated of how many were valid? I need that updated. I want to make sure that was updated, even if it doesn't make the 500. I want to see a 400 and whatever. Because I really don't, getting disenfranchised like that, it obviously was blatantly. He obviously blatantly didn't care about my particular petition. Maybe I'm just someone who does not, who can get ran over like that, because that's just, it was ridiculous.
Well,
And
I want to say this.
And it should be put out to, I want to show people. I want it to be,
I disagree, that anybody who works here at the Board of Elections is blatantly or intentionally trying to stop anybody from having signatures validated in your favor. They do a great job as a bipartisan team. There's nobody who has any reason to stop you from being on the ballot.
You guys have a projector, like, or some way I can do a PowerPoint presentation? I would love to put it together for you.
Well, I think with the course of action, he was stated that
Okay.
file for reconsideration, get your invalid that you say are valid, bring your evidence why you think these are valid. Staff will check it out. You still have to get to 500.
Sir, let me also suggest that this gets fairly complicated legally. You might consult with an attorney. As you've seen, we'd have an attorney here today representing 3 different entities, best I can tell. So it gets pretty complicated, and the board is not in a good situation to give you legal advice, nor should it, So there's a procedure we have to follow, and I think Mr. Linzer's suggestion is the right one, because at
It
this
is.
juncture, any meeting, ultimately, I think could jeopardize even the board's legal position.
That's
So,
true.
yep.
That's true.
What do you mean?
Well, no, what Mr. Linzer just repeated. Mr. Linzer, one more time, can you repeat what you just stated?
Once the board has, and Dave, correct me if I misstate this, but once the board has rejected a candidate's petition, the candidate can ask the board for reconsideration of that decision. It is up to the board whether or not it decides to reconsider its decision, and once it does, it can accept evidence and it can act on new evidence to revisit that decision.
That's a fair statement.
Yeah, well, if I could show 50 instances, can you have? If I can actually show 50 instances, which I know I can, I only looked at 10 of them out of the 38 that I turned in. So if I can show
Mr.
50
Israel.
instances, yes. Will you guys? I just want to make sure.
Mr. Israel.
It will get considered.
Mr. Israel, you have to get to 500. You have to show evidence on 145 new signatures
Oh,
that
it
the board was
133.
incorrect.
That's cool. That's great. I mean, like I said, it's so blatantly messed up. The petition is so blatantly messed up. I would love to do that.
Okay.
Yes.
That's
Where we are.
that's what we want to do.
Yes,
Okay, thank you.
definitely. So
Thank
when
you,
would
sir.
I be able to do it?
Sir?
When would I be able to do that? Just put in the motion, and then hopefully you guys may hopefully pick it up. Is that how it works? I'm trying to get.
Now, you need to
understanding.
have it to us by close of business tomorrow, just like Mr. Hartman does, and
Close
we'll
of business
consider it on Thursday morning.
Oh, sounds great. So on Thursday, I will definitely have it in.
Thank you.
Thank you, sir.
Thank you. All
Thank
right.
you,
Thank you,
sir.
sir.
Anything else? Need a motion to adjourn?
No, we have
Oh,
something
I'm
else.
sorry. Oh, my goodness. I am so sorry.
It's all good. I just want a quick comment.
Could you please share with us your name and your address, please, sir?
Yeah, yes, ma'am. I'm K.A. Harry Jr. You said my address?
Your name's fine.
Oh, that's cool. All right. But yeah, I just wanted to come up here and say thank you to the board for accepting my initials and everything. And hey, Mr. Joe and Ms. Dad been holding it down in finance. I appreciate you. But also, I just got a quick question. I'm actually from Westwood also. So from Ms. Powell, since she not here, and I feel like some new information got out. Does she need to be here on Thursday? And also, would it help for her to have affidavits also for the date that was missed?
Yes and yes.
Okay, and does she need to have that in by Wednesday, by the end of the day?
I think
Okay.
that would probably be appropriate,
That would
yes.
be very appropriate, yes.
Okay, I will relay that information to her. Then how long does it take for it to go through the state, the Ohio Supreme Court?
Well, we're actually, we have a 2-2 vote that will go to the Secretary of State. We typically have 14 days, but I was going to see if the chair would agree that we get it submitted
And so we're going to make that call on Thursday.
Thursday. I mean, we should get there
So-
quick on behalf
But
of the.
we're under a tight timeline, so we're going to do everything we can to expedite the process within a reasonable time frame.
Okay.
So, but that's a good question.
Okay, perfect. So yeah, I'll make sure she get that information, have it whatever she needs in by Wednesday at the end of the time, and then tell her. So it's gonna be at 8 o'clock
8 o'clock.
on Thursday. Okay, perfect. Thank y'all.
Thank you.
Thank you, sir.
Thank you, sir. Is there anyone else? Because I don't want to omit or cite anyone.
Madam Chair, just one more item from staff. You have in your packet a diagram of
Oh, yeah.
our facility.
Yes.
With our intent to use what's laid out on this diagram during the early voting time period. very few, just a few adjustments in compared to last November's election, and that we've added 2 additional campaign areas to the facility. If you look, they both are located on the left-hand side of the building we are currently in, indicated by the orange sort of triangles on each corner. If the line would extend to that point, it's our intent to add those campaign areas.
Okay.
We just
So we
wanted,
have outlined very clearly where the exits are, and then also the process, if the lines become longer, how it's going to wrap around Smith Road down to, where past the
to Wall
drop-offs.
Street.
Right.
Correct.
Okay.
So the triangles are 10 feet from,
Yes,
Okay.
yes, they'll be 10 feet from the line. Again, this is in order to obviously allow for campaigning, and then also to, for safety concerns regarding the flow of both pedestrian and vehicle traffic through the parking lot.
How does this, well, from my perspective, it looks like you've created a diagram and a plan that's going to make it easier for everyone, the voters in line, giving them a clear outline of where they're going to be, as well as getting the campaign neutral zones established so that we don't have that issue like we did in 2020.
That's our hope. It's also the deputy director and I, our intent to send this diagram along with just a white paper regarding campaigning in Ohio, in Hamilton County, sort of the do's and don'ts to the candidates involved in this election, just so that everyone's has the same understanding before the election cycle begins.
Great. Thank you. This is great. I don't have any questions. Thank you. It seems self-explanatory to me. How about the board?
Nothing else?
I like the layout, but what are we going to say about the voters who don't want to go by the, once we get past 100 feet, they want to stay within the 10 feet, not just in the areas we designate, but they want to be all through the line.
Right. It's our intent to, the deputy director and I, along with the administrators and staff, went outside, we walked the area. And I know you've been here the board has been here during that busy time when you have such heavy pedestrian and vehicle traffic. And we feel like this is the plan that will allow for both safety of those at our facility and the campaigners to have access to the voters following Ohio law. We think this is the best plan.
Okay.
We shall see how, when that day comes. At least we've got a plan, which is very clear. So then we will begin to trying to work out any kinks. It appears to me from looking at this diagram and thinking about the way it was in 2020, this gives a clear picture of the flow, and hopefully it works.
That's our hope.
Yes. Okay.
Hopefully we won't have a line.
Hopefully. Hopefully we will, but if we do, then it'll be orchestrated well. Thank you. Is there anything else, Ms. Poland or Mr. Linzer?
No.
Need a motion to adjourn the meeting?
I'll move that we adjourn.
Second.
Motion's been made and second. And all those in favor?
Aye.
Aye. Anyone opposing? Anyone abstaining? As I always say, only the devil would be doing that today. Thank you.